welcome all the participants and welcome all the speakers for this wonderful session which is coming up, and that's the panel discussion for the day. So the topic is digital brand protection challenges and solutions to prevent infringement and counterfeiting globally. We have our speakers joining in: Christian Maury Panis. She's a executive vice president, general counsel and public affairs via Access Orca. We have Claudio Castanheira. He's the managing director Brazil from Clarke, Modet and Company, and the moderator of the session, Smrithi Mohan, senior attorney and leader, global innovation and intellectual property strategy, World Intellectual Property, Dun and Bradstreet. So over to you, Smrithi.
Thank you so much. Hi, everyone. Thanks for joining us today. Before we begin, I want to recognize my co-panelists for being so wonderfully color coordinated. As you can see, we are all dressed white today to share our team spirit with all of you. I'd like to kick off the discussion with a brief introduction to online infringement and the legal landscape of online infringement. I think understanding online infringement is a brand owner's first line of defense. As the brand owner, you need to first recognize and define the problem in the context of the brand owner's specific business before developing an effective strategy for combating online infringement. It's easier to recognize physical infringement, such as knockoff purses. Online, legally, trademark owners have an affirmative duty to monitor and take action against unauthorized use of their marks. If a trademark owner does not exercise vigilance in policing the proper use of its trademarks, those rights could be compromised and even lost entirely. Online infringement can take place in the form of impersonation of a brand owner's website or social media pages, integration of a trademark in domain names or social media handles, use of proprietary images or content, sale of counterfeit or infringing products or services through counterfeit websites, the use of the same or similar marks of the brand owner in advertisements and promotions and marketing materials, impersonation of a company's personnel. I mean, the list goes on and on and on. There's so many different forms that online infringement can take. And when it comes to dealing with online infringement, one of the biggest challenges that brand owners face is really knowing how to proceed with online enforcement once they discover that their IP rights have been violated. The Lanham Act, for example, is a United States federal statute that governs trademarks, service marks, and unfair competition. But since it was enacted by Congress in 1946, well before the internet ever came into existence, it requires that the infringement happen and take place by a person. So then what constitutes a person in the online world? What if the infringement is by an artificial intelligence driven algorithm rather than a human person? So there is a lack of clarity and uniformity found in many IP statutes all over the world, sometimes because they're outdated, which poses a big challenge for businesses and IP practitioners since online infringement continues to grow year after year. So as a solution to avoiding online infringement as much as possible, and because of the gray area that many acts and regulations pose, the best thing you can do is to protect your brand digitally and prevent infringement and counterfeiting globally by developing a strategy that is focused on protecting your most important and publicly recognized IP assets. So now that I've talked a little bit about online infringement and the legal landscape generally, Christine, I'd like to direct the conversation to you, and maybe you can provide any examples of online infringement that you have seen, along with your perspectives and the challenges that online infringement poses.
Yeah, absolutely. Thank you, Smrithi. I will focus a little bit on this very special online infringement, which has another name, which is known to everyone, which is illegal streaming. I'm sure I'm not going to explain what illegal streaming is about. We all know that. And today, this is certainly the biggest form of audiovisual piracy. Well, you certainly all remember in the old days, piracy of content. That was with pirate cards or, of set-top boxes and things like that. And okay, it was very much in line with the technology, and sometimes the technology was a bit weak, could be pirated and something. With illegal streaming, this is totally agnostic. This is technology agnostic. This is something new. And as you said, Smrithi, as part of this online infringement, this is a growing practice. And this is something that COVID has boosted, unfortunately. So just to give you a rough idea, of course, we can find many figures. Everybody has his own figures and there are surveys everywhere. I will just give you three sets of comparisons so that you understand a bit the outreach of this phenomena. If you talk, for instance, in terms of revenue, we estimate in general that the revenues derived from SVOD were around $50 billion in 2019, and they are expected by 2025 to grow to something like $100 billion. If you look now at the revenues derived from illegal streaming, then you will see that we are quite close. Because in terms of 2022, we are expecting a figure by $67 billion. And of course, this is something that will keep growing. So as a minimum, we will see that the revenues derived from legal consumption of content and the ones from illegal consumption, then they will be at least more or less the same. Another way to look at it, for instance, is if you are talking in terms of numbers of subscribers. If you look at France, for instance, then what you could see is that we have currently 6 million people watching illegally content, which is quite a lot. Among them, we used to have 2 million dedicated to live sport because this is one of the, let's say, the biggest part giving rise to piracy. Now they are 4 million. And this is a bit the same trend in the UK. And this is even worse, for instance, in Asia Pacific, because certain recent surveys estimate that 50% of APAC consumers watch pirate streaming websites, and the figure is even 66% in the Philippines. So this is reality, but you cannot just take the figures as such. What is very strange in this online infringement, beyond the fact that it is booming, beyond the fact that COVID has boosted it, what is very strange is that actually this is a complex picture, because this is not an easy word. You're on one side watching legally, or you're on the other side watching illegally. This is very different. You can be on both sides, and this is reality. What reality shows is that, yeah, it's not because this is illegal streaming that this is free. It has a cost as well. You buy exactly the same sort of subscription. What you have more is that your subscription covers much more, meaning not only the subscription of a given pay TV operator in a given country, but it covers a lot. But still, it has a cost. And then second, people, as I said, are not black and white. They have a mix of them, meaning they use both. For certain things, they use illegal services. For certain, they use legal services. And in order to complexify a little bit more, then where we see that definitively this is a habit is that certain of these contents and many of these contents, especially in terms of live sport events, they are freely available. If you look at the Olympics, for instance, we at least in France, we could watch nearly all the programs, all the events, But still, when we're using for one of our customer our tool that is crawling the internet and seeking all the links bringing to illegal sites where you could illegally consume these contents, then we found an awful lot of them. On 1 week, we had perhaps 157,000 of these links. And still, everyone you could watch everyone. I mean, I was watch the Olympics on what I would say regular TV without having to go elsewhere. But still, so just to give you this overview beyond the figures, this is a reality, but this is very complex. Actually, there is no black and white situation.
Yeah, thank you so much, Christine. I really appreciate your take on audiovisual piracy, and it reminds me of things like that peer-to-peer file sharing service like Napster from the late 1990s, which landed in so much legal trouble with their infringement issues. And it's incredible how some of these issues have existed for 20 to 25 years at least,
Yes.
and you talked about the Olympics, but I think, infringing websites like that exist across sporting events at large, right? I mean, I've heard of so many of these. And, do you think you could talk a little bit about how to tackle some of these challenges and who should tackle them, and some of the, the technical and legal implications of all of the awareness campaigns led at the European and Asian levels by the EU and their alliances to fight audiovisual piracy?
Yes, of course. Yeah, well, how to tackle this? This is a variety of measures. So you have technical measures. I would roughly put two categories. One category would be the technical measures. The second one, the legal and awareness measures. In terms of the technical measures, of course, and I'm sure that this is exactly the same for for counterfeit, for brands. We all use more or less tracking tools that are effectively crawling the internet, and that will allow you at least to have an idea of the scope, of the total scope. So the tool crawls the internet and then looking for all the links bringing to the illegal streaming sites. And then what certain tool do as well is that they can notify certain of the stakeholders, because we will see it after. But as you said, this is an ecosystem. This is not solely two person, the consumer and the ISPs or the content owner. This is much more bigger. And it notifies the UGCs, the ISPs, the CDNs, and then certain of them can also remove the links directly or de-index them quite quickly. So this is a first tool. At least you can measure in the course of your event what is the number of links and have an idea of the number of illegal watchers behind, and make a first thing, which is send notifications. Another technology we could be using in the coming years is artificial intelligence. When we are developing a tool, for instance, that we call bridge detection, and it will allow you to detect anomalies in the TV data stream. I mean, when you watch something with your device, there is a device number, and then you have all the numbers and all the network, can be million, of course, and then looking via artificial intelligence, you can analyze, and looking at the behavior of the devices. Then, if there is one, for instance, that switches off or on constantly or whatever, then you can detect some piracy behaviors. So that's another way via technology of trying to better understand the situation. And of course, you have watermarking, which is a preventing approach, and you can watermark the content, and then you use some identifiable invisible video tag, and then it can allow to detect content which is pirated and to give you the source of the leak. And after, you can take measures at God level. So yes, technically we have means that allow us to measure the scope of piracy and to have some form of answer, like dereferencing, de-indexing, and seeing effectively the behaviors. Having said that, this is not enough, of course, and then you have to double this with legal measures. So, of course, everybody will immediately tell you, and I'm sure that this is exactly the same for trademark. They will tell you, okay, this is the question of blocking sites, and we all know that. So, up to now, there was everywhere legislation, but perhaps not so advanced. And what you see for the time being is that, at least in Europe, there is a bigger effort in terms of making this blocking of sites a bit more efficient, a bit more effective. And for instance, you will be able in more and more countries to get kind of dynamic orders, and then you will extend the effectiveness of the measures to block a given illegal site to what you call the mirror websites, meaning the new websites that will appear with exactly the same content, and then you will benefit, not have to go to court again, but benefit from the same measure, and that same measure can be extended to 12 months. This is something that we are looking for to introduce in France, for instance. In Germany, they also saw that it was not so efficient. So they're trying now to set up kind of independent office, and then you could apply for an order to that office. And what the office would do for you is that it would check and review your application and liaise with the court. So it helps court a lot. And then once there is a blessing of that office, then it's easy for the order for the court to issue the order. And we see a bit more in Asia, also Indonesia and Thailand. We see these kinds of initiatives. So this is another way, another legal way of trying to block this. But as we said, it would mean that this is simply a story between the consumer and the content owner, and, for instance, the ISP. Or but this is not the case. Actually, basically, for audiovisual piracy, what we've seen is that this is a full ecosystem behind. And you have many stakeholders. You have not only the ISPs or the consumer, but you have the app stores, you have the payment providers, you have the domain names, you have the social media, the ad servers. So it means that you need also to start having measures and to talk to all these people, because if you don't talk to the app store, you can easily download all the apps and then you're done. And you can get all the site blocking you want. If you can still continue with the apps, it's easy. So where this is the second part on which I would like to insist, of course, is, and I'm sure we all do that, is in developing awareness. Because before you can ask these other stakeholders to play an effective role, you have to make sure that everybody is aware of the situation and that they are aware of the role that they play, voluntarily or not, in the ecosystem. See, for instance, the social media in the, let's say, last years, in terms of this tracking, for instance, we saw that most of the links were on the social media. Nearly 30% were on Facebook or whatever, just for the live sports. It is a bit less now because we've been talking to them and been introducing measures and so forth. But this is the case. You have to create awareness, and effectively, this is what we do in Europe via the associations or via the EU Intellectual Property Office of Alicante. We work a lot with them, and this is what we do. So creating this and working with Europol, working with Interpol to explain the situation. We've been developing online course for them to explain exactly where to search, what to do. And this is only via this joint work that you are going to see certain results. And we see the first results because, very regularly, the EU Intellectual Property Office has what they call perception study in terms of IP. And one of the things which is very clear now is that even at the level of the consumer, people understand what they do. In the early days, they might not understand very much what they were doing in terms of content. In terms of trademark counterfeit, they understand. This is a little bit different. You can be a bit misled with all the subscriptions, with the apps and so forth. So now they know. And I think that this is already a first challenge that has been won, which is everybody knows. After, there will be a second challenge, which is now that everybody is aware, how do we transform this awareness into a real willingness to change the habits? But this is basically where we stand, and for the time being. So the, this always should be a mix of all of these technical measures, legal ones, of course, boosting a bit the courts, boosting these blogging sites, and continuing awareness creation.
Yeah, absolutely. Thank you so much, Christine. Incredibly helpful insight. I think so much of what you just talked about builds on what I was also talking about earlier, and the need to really develop a comprehensive online IP protection strategy, which is really one of the best things that you can do to protect your brand. And that effective strategy, it needs to be really inclusive and contextualized for the current business and the legal and the technological environment, as you mentioned, and while simultaneously being based on the brand owner's goals and their objectives and their resources. And when you pay attention to how online infringement occurs and how it affects brands, it helps you as the brand owner to focus solely on efforts and targeted solutions for your own specific situations. And your strategy has to incorporate that range of prevention and detection and response procedures to enforce across the internet. And most importantly, you should make sure you apply for IP protection, including trademarks and service marks, domain names, copyrights, even things like social media handles. Sometimes when brand owners try to file trademarks in jurisdictions where they're doing business, they sometimes discover that their brands have been registered by trademark squatters. And trademark squatting is when one party intentionally files a trademark application for a brand owner's trademark in a country where the brand owner doesn't currently hold a trademark registration. And they take advantage of that first to file trademark system that exists in many countries. Then that's actually very different from the United States, which uses a use-based trademark system where the trademark rights are acquired by priority of use. So when bad faith filers obtain registrations in a particular country, they're treated as the legal trademark owner in that country. And sometimes this happens because the bad faith filer wants to sell counterfeit products and services of that brand. And sometimes it happens because the bad faith filer wants to truly, they want the true trademark owner to purchase the trademark registration for some absurd price. And, many will pay that price to avoid dilution of their brand. So, to avoid this from happening early on, brand owners should really file for their trademark application early in jurisdictions they not only do business in currently, but also where they think their business will expand to in the future. That can really help. And like you mentioned, Christine, strategies that incorporate the use of machine learning and artificial intelligence and big data. You spoke a little bit about this as well, right? And these strategies can continuously monitor for counterfeits across digital platforms and marketplaces to help locate and help, hopefully eliminate, from the internet, unauthorized and potentially harmful services and products that are fake. And it can help to implement a way to detect online infringement and perform necessary takedown procedures with the help of a good security person or team, and potentially also send cease and desist letters, which we have had success with many times at my own company when tackling online infringement. And many times sending one can actually deter the infringer from continuing and can result in dismantling and any infringing websites or elements and seizing the infringement altogether. But other times the infringement, the infringing activity itself can continue, in which case you can, petition, at least in the United States, petition the court to make a strong argument in, that the alleged offender's actions are illegal. And if a determination is made that this is true, a cease and desist order is given by a judge to order the party to cease infringement. And, upon issuance of a cease and desist order in the United States, the offending party will be ordered to cease and desist certain actions until the hearing is held. And this formal order is legally referred to as a temporary injunction. And the temporary injunction will remain in place until a hearing is held to determine whether or not the order shall remain in place indefinitely. And since this can be costly, many times the offender can stop before it goes this far. Claudio, I want to direct the conversation to you. We've heard a little bit about the current landscape and the challenges and the solutions as they are in the present. So how do you see digital brand protection evolving in the next 5 to 10 years? And what do you think are the next steps towards development and solving some of the additional challenges we face?
Thank you, Smrithi. Well, a lot has already been said. I don't know if I'm going to bring something new. But yes, this is a huge problem. We see, and I think this section is very good because there's these two words that they have a lot in common, but the techniques and the type of solutions are a little bit different. The streaming, video on demand world, and the brand protection, because we are talking about social medias and marketplace and things like this. Might be a lot of overlap, but they are a little bit different. And I think the two of them are growing a lot. So in terms of e-commerce and the digital brand infringement, I think the relevance comes from the fact that we are more and more buying online. So e-commerce already represents something around 20% of the total trade or retail sales in the world, and this is expected to grow to something like 25% of the total retail sales, right? So e-commerce is becoming more and more appealing to the new generation. So people are bored already buying only online, and the number of new buyers or buyers that buy for the first time online grow every year, right? In UK this year, 2021, 15% of the people that didn't buy last year online never bought before last year online, so bought this year online. So there's a huge new crowd of people buying online, and this and infringements and fake products and is booming. And so this is a problem in the physical world. Billions, hundreds of billions of dollars of fake items and unauthorized items being sold, and it's not different in the digital world, but brings a lot of concerns. I think we talked a little bit already, health concerns, the number of fake items from the pharmaceuticals industries are increasing. The total, economic impact of this is huge, right? So this has to be tackled quickly. So if we look forward, I think the problem is getting more complex. The problem is getting more impactful. So we need to, support, the public and the companies to come to solutions. So the problem, spreads around, social media with brand abuse and fake profiles in the social medias. It's on the domains. You talked about squatting, but there is cyber squatting websites, fake websites, typo squatting with websites that simulate a little bit the name of the real owner. So you have search engine problems, advertisements, processes in Google and other search engines that simulate the fake item appears first and things like that. And marketplace is something maybe one of the worst problems nowadays with sales of counterfeit problem, illegal importation, and brand abuse all over the place. So these things are spreading out, and the problem is spreading out. I think the main challenge for the future will be in two main buckets. The first one is for the clients, for the companies, right? So how they not only identify the infringement, but also how they utilize machine learning and artificial intelligence to keep on with the changing habits of the infringers, right? So infringers are all the time changing profiles in Facebook and Instagram. Once they get caught, they change the name, they change the codes of the fake products, they change, the way they advertise. So you need to constantly be, learning how to identify and to track these behaviors of the infringers, right? And this is only possible with the scale that we have today. This is only possible with a lot of intelligence, data analytics, to keep your detection tool efficient. Otherwise, you're going to be losing for them all the time. The second problem I see is how do you validate a detection that you did, right? So maybe your tool is very good, but it will never be 100% precise in detecting and confirming that this is a fake item, right? So maybe it detects something that there's always a probability that this is a false positive, right? So how do you process that and make sure that you are going to take down precisely what is fake, right? And this has to do a lot with how trusted you are to advise the platforms or the social medias that that this is fake, right? So this is done typically by the tools, right? There's a lot of tools now that detect, and they connect with the platform or the marketplace, etc., to take down. But these trust relationships, right? Because the marketplace, if they take down something that was that was not illegal, they suffer, right? Probably they will suffer some court proceedings for being taken down, for taking down somebody that was legal, right? So they have to be careful, and the tools have to be precise. And this relationship between how the trust relationship can be jeopardized if the tool is not good or the trust program is not very good. So the more these tools are trusted, the more efficient will be the takedown, the quicker it will be the takedown, and this will be better for all. So this is, I think, the two challenges is how to keep on with the changing habits of the infringers, and how to keep the trust relationship, or to increase trust relationships between the identification tools and the takedown of the social medias.
Yeah, I think that's a really helpful outlook. And what you said earlier about e-commerce is very interesting. It's true. It represents such a huge percentage of sales worldwide. And it's important to note that things like, these unexpected situations that we're in, like the COVID pandemic, have increased, considerably to e-commerce, especially over the past year. You said that there was a boom by people who have never been part of the e-commerce world previously in the last year and are now part of that. So to build on this point about e-commerce, I want to ask you how you think consumers can protect themselves from counterfeit products or misused brands.
That's an interesting question. I think this is done in 4 steps. And this is very strategic, right? The first step is to understand the buyer, your customer, right? How your customer buy, which are the main, marketplace, how they search, how your brand appears in the search engines, how your brand, if your client, the consumer goes first for a physical store and then search on the internet before buying. Really, you have to understand the behavior, the average behavior of the customer, right? And then you have to understand the behavior of the infringer, right? So the illegal, the problem of unauthorized trade or unauthorized use of your brand or unauthorized something that impacts you, right? So this mapping is very important, right? So you have to have an X-ray of how the digital world, how your product is behaving in the digital world, right? And then the second step would be to select a tool, right, for detecting, right, these infringements and counterfeit products related to your business. Selecting this tool is critical. A good tool is critical, and making the parameterization of this tool in a efficient way is very critical, right? So the types of search, the efficiency of the parameters that you're going to use to have a precise identification, right? And then, as I said, how this tool is updated in terms of behavior of the infringer, and how and the capabilities of this tool to provide you with data analytics, right? So how do you confirm that this is a falsification or a problem, and how you can your capability to track down the the root of the unauthorized products, right? So being able to do this type of analytics is I believe is very, very important. So the tool has to be efficient in that way, right? So it has also to keep evidence of infringement. It has to have a routine of update of this parameterization, as I said, but this is more obvious, right? Well, the third is the takedown procedures, right? So the tool needs to be trusted, as I said before, right? So the reach of the takedown channels that the tool has is very important, right? If it can reach globally, all the marketplace in the globe, or just in one country, etc. It's very important this breach of this trust channels that they have, right? And the last point, the fourth element is be prepared to if the automatic takedown doesn't work, as you said before, you need to go through the normal routes, right? So the pre-court proceedings, like cease and desist letters, communications with the infringers or with the host servers, block the sites and things like that. You have to force through legal measures what to do. You can also act with the customs, right? So trying to block the flow of the product in the origin or in the destination in case of importation of goods, right? And you have the injunctions and the court proceedings, regular court proceedings. So you have to be able to mobilize this legal, infrastructure all over the place as well. So I think these are the 4 elements that companies need to be, prepared to mobilize.
Yeah, I really like this perspective, and I appreciate you being able to offer some insight from the consumer angle as well. Fundamentally, I also think it's important to note how consumers search for goods and services. You know, the vast majority of searches don't actually begin with the brand's website or an official mobile app, right? But it's rather through a search on the user's mobile or computer search engine, and most perform a search for what it is they're looking for. And it's possible that they land up on a counterfeit or fraudulent website that's not affiliated with the original brand, but it looks like they are. You know, for example, where I work for Dun & Bradstreet, and we provide a unique numeric identifier called a DUNS number, which is the data universal numbering system. And we provide that to business entities. It's used around the world to identify and access information on various businesses, and we offer these numbers for free. However, it's happened in the past that when you perform a search for obtaining a DUNS number, sites that are not affiliated with our official site, which is dnb.com, those pop up. And these sites, even though we offer this number for free, these sites are often selling DUNS numbers, and many consumers have fallen victim to this. So we've performed the standard takedowns and sent cease and desist letters and, you know, to the infringers. And so sometimes, you know, it happens that you have to take active steps to protect your brand, but you still have to deal with, you know, your infringers and address them even when you're taking those active steps. And Claudio, like you said earlier regarding cyber squatters, sometimes, you know, we'll succeed in taking down one website and then they pop up somewhere else, and it just becomes this vicious cycle, right? And, you know, so it forces us to become stricter and more diligent in our processes and, you know, with monitoring and takedown efforts. You know, in general, I think the rise in the use of online marketplaces and shopping platforms by many companies to market and sell their products also is mirrored by an increase in the volume of the fraudsters and counterfeiters on these platforms who like to, you know, piggyback off of the work and the investment of the original brand owners. So this all of what we've been talking about ties back to the need for that comprehensive brand protection strategy, you know, to protect both the brand owner and the consumer. Christine, really quickly, I want to come back to you for a moment. Do you mind shedding a little bit of light on cyber criminality and the threats against online infringers, whether it be for brands or for audiovisual content?
I think that this is cyber criminality. This is certainly something that could be a potential deterrent, have a potential deterrent effect on this online infringement, because one of the things that we've seen in the course of the last month, so this is quite new, is that many consumers of whatever counterfeit or illegal content, then they have had problems with the integrity of their data after they have been to one of these infringing websites, and certain of them have complained that their own data have been stolen, and this is where also certain consumers have started to realize that basically there is a vulnerability of their digital presence. And I think that in the coming years, the fact that when you go to many of these sites have a tendency of stealing your data, then this is something that can have a kind of effect on the consumer, because I mean, nobody wants to see his data stolen. And I think that if effectively whatever pleasure they have had in going to this website to purchase a counterfeit or to consume a content which is protected, then effectively this could also a bit reduce this habit of going to certain of the websites. And more certain offices, the EU IPO has that, and WIPO as well. They have lists more and more. There are lists of these fraudulent websites where you can have your data stolen. So perhaps this is also something that will make that going to these sites will make you think twice in case your data have been stolen.
Thank you so much, Christine. I think we have to wrap up. So, in conclusion, do you mind if each of you kind of provide a key takeaway? Christine, would you be able to provide a key takeaway for our audience?
I think that a bit as Claudio said, whether online infringement deals with counterfeit or with content, there are many overlaps, and I think that awareness is key. And because a lot of this, at the end of the day, is a question of mindset. And this is certainly what will be the most difficult, working on the mindset rather than simply on, having better tools, of course, or having better legislation or quicker court decisions. This is, for me, what worries me the most is online.
Thank you, Christine. Claudio?
I completely agree with Christine. Working on the minds of the people, on this awareness, building awareness. This is the most efficient, maybe the most efficient tool, although never be perfect. But if we would like to tackle the problem, I think we need to increase awareness of the criminal reality that is behind all this problem in the digital world. This is the most efficient.
Yeah, that make that 3. We're all aligned. I think that's definitely the biggest key takeaway. And just do your best to protect your brand. At the root, just do your best to protect in jurisdictions that maybe you may not even be in yet, but you may potentially be in. Just take active efforts to protect your IP and build that strategy. So, thank you all so much for attending our panel today.
Thank you. Thank you, Smrithi.
Very
Thank
good.
you, Claudio.
Thank you both.
Thank you, Christine. Thank you, Mr. Hendry.
Thanks, Smrithi. So we have one question on the chat box, and that's from Brian. So I hope we have answered that, or if not, we can read that. In the US, is the Computer Fraud and Abuse Act a tool in the toolbox? And if so, to what extent? So if someone would like to answer and comment on that.
That's an interesting question. I think the Computer Fraud and Abuse Act, it outlaws conduct that victimizes computer systems. So, it's a cybersecurity law. It protects banks, federal computers. But, I'm not sure, to be honest, to what extent it would be a tool for this particular instance. So, I can look into that and get back to you offline, Brian.
It's very specific to US, right? So
exactly, that's you, the US.
All right, sure. So, Brian, we'll get back to you. And Smrithi said that she's promised you to get back to you on this answer. So, we'll be connecting you with her over the email. And thank you, Smrithi, for moderating a wonderful session.
Thank you.
And as always, so thank you so much for contributing with the IPR Gorilla, and to Claudio and Christine. Thank you so much.
Thank you.
Thank you.
Thank you.
thank you.
Thank you.
So, bye from here. See you, Smrithi.